There are moments in law that don't feel immediate when they're happening, but months later, they quietly reshape how millions of people live, move, and make decisions. Right now, two major Supreme Court cases are being closely watched because they could redefine how concealed carry laws are understood across the United States. Not in theory, but in practical reality, how states regulate, how courts interpret, and how individuals experience their rights in everyday life. And here's what most people don't realize. By the time a ruling is officially understood by the public, its legal impact has often already begun shaping enforcement and policy decisions in the background. So here's the question. Do you think Supreme Court decisions should set clear, uniform concealed carry rules across all states, or should individual states continue to decide their own approach? Share your answer in the comments. Now, to understand what is actually happening, we need to separate speculation from the real legal framework. There's a lot of online discussion suggesting that concealed carry laws are about to change forever based on upcoming Supreme Court activity. But in my legal analysis, the reality is more structured, more gradual, and far more dependent on constitutional interpretation than sudden transformation. The foundation of concealed carry law in the United States is the Second Amendment, which protects the right to keep and bear arms. However, that right has never been interpreted as unlimited. Instead, it has been shaped over time through landmark Supreme Court decisions that define where the line between constitutional protection and lawful regulation exists. In District of Columbia v. Heller, the court confirmed that individuals have a right to possess firearms for self-defense, particularly within the home. That decision was a turning point because it recognized the Second Amendment as an individual right rather than solely a collective one tied to militia service. Later, in McDonald v. City of Chicago, that protection was extended to apply against state and local governments through the 14th Amendment. This meant that states could not ignore the Second Amendment when creating their own firearm laws. But the most significant modern shift came with New York State Rifle and Pistol Association v. Bruin. In that case, the Supreme Court changed the way courts evaluate gun laws. Instead of using balancing tests that weighed public safety against individual rights, the court introduced a historical tradition test. In simple terms, that means courts now ask whether a modern gun regulation is consistent with how firearms were regulated at the time the Constitution was adopted. In my legal analysis, this shift is extremely important because it changes the entire method courts use to evaluate concealed carry laws. Now, when we talk about two major cases being discussed in the context of concealed carry, what we are really talking about is how lower courts are applying Bruin and whether the Supreme Court will step in to clarify disagreements between different federal circuits. Courts across the country are not always interpreting Bruin in exactly the same way. Some courts have struck down certain restrictions on concealed carry permits, while others have allowed more limited regulations to remain in place. This creates what is known as a circuit split, where different regions of the country have slightly different legal interpretations. When that happens, the Supreme Court often becomes involved to provide final clarification. Courts would likely examine whether concealed carry restrictions in specific states align with historical firearm regulations, or whether they represent new types of limitations that require stricter constitutional justification. There is a strong constitutional argument that broad restrictions on carrying firearms in public must be supported by historical precedent. At the same time, another perspective raised in court is that modern public safety concerns may justify certain structured licensing systems as long as they do not effectively eliminate the right to carry. This is where legal tension naturally arises, because the Constitution does not operate in isolation from society. It is applied in real-world conditions that evolve over time. Now let's talk about federal versus state authority, because this is where concealed carry laws become especially complex. The United States has a federal baseline of firearm rights, but states retain significant authority to regulate how those rights are exercised within their borders. That means concealed carry laws can vary significantly depending on location. Some states operate under shall-issue systems, where permits must be granted if objective criteria are met. Others have moved toward permitless carry, allowing individuals to carry firearms without a permit under certain conditions. And some states still maintain more restrictive licensing systems that are currently being challenged in court. In my legal analysis, this variation is one of the primary reasons concealed carry continues to be one of the most litigated areas of constitutional law. Now let's bring in real-world impact. For lawful gun owners, these legal developments are not abstract. They directly affect where and how a firearm can be carried. Even small changes in interpretation can influence whether a permit is required, whether training is mandated, or whether certain public spaces are restricted. Practical consequences also extend to travel. A person who is fully compliant in one state may unknowingly face legal issues in another due to differences in reciprocity agreements or local regulations. This is why legal awareness is critical, because compliance is not just about intent, it's about alignment with current law, which can shift as court decisions are issued and interpreted. There are also important Fourth Amendment implications in this area. During interactions with law enforcement, courts would likely examine whether searches or detentions related to firearms are reasonable under the Constitution. The presence of a firearm alone does not automatically determine legality, but it can become part of the broader context considered by courts. The Fifth Amendment may also be relevant in certain situations involving statements made during legal encounters, particularly when those statements could later be interpreted in a legal proceeding. In my legal analysis, understanding how rights apply in real time is just as important as knowing that those rights exist. Now, from a political and legal reality standpoint, it is unlikely that concealed carry laws will be completely standardized across all states through a single Supreme Court decision. Instead, what is more likely is continued refinement, case by case, ruling by ruling, clarifying the boundaries of what states can and cannot do. Supporters of expanded concealed carry rights argue that constitutional rights should not vary dramatically from state to state and that lawful individuals should have clearer national standards. They emphasize consistency, predictability, and the importance of constitutional protection. On the other hand, supporters of state-level regulation argue that local governments are better positioned to address specific public safety conditions within their communities, and that flexibility is necessary to balance rights with safety considerations. Both perspectives continue to shape ongoing legal debates. And this brings us to the most important point. The law is not static. It evolves through interpretation, challenge, and clarification. What matters most is not just what the law says today, but how it is being applied right now in real situations. So as we continue into the deeper analysis, think about this. If the Supreme Court continues refining concealed carry standards through these major cases, do you believe the result will bring more clarity to gun owners, or will it create even more variation between states before things settle? Because in the next part, we're going to break down how these cases could realistically impact everyday concealed carry rights, what legal risks could emerge during this transition period, and what lawful gun owners need to understand moving toward 2026. Stay with me, because what happens next is where legal theory meets real-world consequence. As we continue, the most important thing to understand is that Supreme Court involvement in concealed carry law does not operate like an instant switch. Even when a major ruling is issued, its real-world effect depends on how lower courts interpret it, how states respond, and how enforcement agencies adjust their policies. In my legal analysis, this is where the true impact of major cases begins to take shape, not on the day of the ruling, but in the months and years that follow. Courts would likely examine concealed carry restrictions under the framework established in Bruin, asking whether each regulation has a historical analog rooted in the founding era. But that analysis is not always straightforward. History can be interpreted in different ways, and reasonable legal minds often disagree on what qualifies as an appropriate comparison. There is a strong constitutional argument that the right to bear arms in public should not be reduced to a permission-based system that varies widely from state to state. At the same time, another perspective raised in court is that structured licensing systems can coexist with constitutional protections, as long as they do not effectively eliminate the right itself. This legal tension is exactly why these cases matter so much. Now let's talk about what this means for everyday lawful gun owners. Even without a dramatic nationwide overhaul, changes in interpretation can have real consequences. A ruling that narrows or expands state authority can directly affect permit requirements, training obligations, or where concealed carry is allowed. In practical terms, this means that what is considered lawful today in one state may be adjusted tomorrow through court clarification or legislative response. And this is where legal risk becomes especially important. In my legal analysis, one of the most overlooked realities is that most legal issues do not arise from intentional violations, but from outdated assumptions. A person may believe they are fully compliant based on prior understanding, not realizing that a recent ruling or policy update has changed the requirements. Courts would likely consider intent, but compliance is still measured against current law, not past expectations. This is why staying informed is not optional. It is essential. Now consider federal versus state authority again, because this remains central to concealed carry law. Even if the Supreme Court sets a national constitutional standard, states still retain authority to regulate within that framework. This means variation between states is not only possible, it is expected. Some states may expand access to concealed carry in response to court rulings. Others may adjust their laws more cautiously, testing the limits of what remains constitutionally permissible. Over time, these differences may narrow, but they do not disappear overnight. From a Fourth Amendment perspective, interactions during lawful stops or investigations may still involve careful legal evaluation of reasonableness. Courts would likely examine whether any search or detention connected to a firearm is justified based on specific circumstances, not assumptions. And from a Fifth Amendment standpoint, individuals retain protections regarding how statements are used in legal proceedings. But again, the key principle is that rights must be understood in context, not in isolation. Now let's talk about the political and legal reality heading into 2026. It is unlikely that concealed carry laws will be unified into a single, identical national standard through one ruling. Instead, the more realistic outcome is continued incremental change. Courts refine the rules, states adjust policies, new cases emerge, and the legal system slowly converges toward clearer boundaries over time. In my legal analysis, this gradual evolution is actually how constitutional law is designed to function. It is not meant to change everything instantly, but to adapt through structured interpretation. Supporters of broader concealed carry rights argue that this process should lead to greater consistency and fewer state-to-state differences. They believe that constitutional rights should not depend heavily on geography. Supporters of state regulatory authority argue that local conditions matter, and that states should retain flexibility to address public safety concerns within constitutional limits. Both perspectives are actively shaping how courts and legislatures respond. Looking ahead, the most likely scenario is continued legal clarification rather than sudden transformation. Future Supreme Court decisions may refine how Bruin is applied, particularly in cases where lower courts disagree on interpretation. But even then, the law will continue to evolve case by case. And this brings us to the most important takeaway of all. The legal system does not operate on assumptions, headlines, or simplified interpretations. It operates on precise definitions, structured reasoning, and evolving precedent. For lawful gun owners, this means responsibility does not end with obtaining a permit or understanding a single ruling. It requires ongoing awareness of how the law is being applied in real time. Because when legal standards shift, even slightly, the practical impact can be significant. So as we come to the end of this discussion, I want to leave you with one final thought. The question is not only what the Supreme Court may decide next, but how those decisions will be understood and applied in everyday life across different states, communities, and situations. Do you believe the current direction of concealed carry law is moving toward greater clarity and consistency? Or do you think the differences between states will continue to create confusion for responsible gun owners in the years ahead? Share your thoughts respectfully in the comments. This is an important conversation, and civil discussion helps everyone better understand the law we all live under. If you found this breakdown helpful, make sure to subscribe for more clear, fact-based legal analysis on real issues that affect everyday rights and responsibilities. Because at the end of the day, understanding the law is not just about knowing what is allowed. It is about knowing how to navigate it with confidence, responsibility, and clarity, no matter how it evolves. And that is what truly defines informed citizenship in a changing legal world.